Good afternoon. Welcome to Undoing I Do with Stephanie and Aday. I'm Stephanie Hunnell, the owner of the Hunnell Law Group in Asbury Park, New Jersey, and your co-host today.
And I am Adela Sherilyn Dow, the owner of the law offices of Adela Sherilyn Dow, located in Staten Island, New York. Also your co-host for today. We are so excited, Stephanie, to have my girl, Kara Kingston, on.
Hi.
Hey, Kara.
My name is Kara Kingston, and my office is in New York and New Jersey, and I practice bankruptcy law.
Welcome.
So, thank you for having me on the show.
We're really excited to have you. You know, I was just reading, I would say the newspaper, but I don't read the newspaper anymore. It's online. Everything's online. But the unemployment numbers were coming out, and there's like 963,000 new unemployment claims filed last week.
Wow. Yeah.
And that's down from the 1.2 million that was filed the week before. So I think talking about bankruptcy right now in this economic time, in these economic times, is really important. So excited to have you on.
Thank you. I definitely agree. It's really hard times for a lot of people today with everything going on. So
yeah, and I think that it's so important for us to talk about the intersection between family law and divorce and bankruptcy, because these are two areas that can really impact the layout of somebody's future. So I guess to start off, we want to talk about bankruptcy in the context of the intact family, and then we'll move on to talking about what bankruptcy looks like when people are getting divorced, already divorced, or just about to be divorced. So, Kara, can you tell us about how someone's spouse is impacted in the event that that one spouse decides to file for bankruptcy? How does that work?
So, in general, when couples are together, they can decide whether they want to choose to file bankruptcy either together, married, or separately if they're separate. But if they're married and they file taxes together and their finances are together, then they file together. If one spouse decides to file and the other spouse decides he doesn't want to file, she doesn't want to file, it shouldn't impact the other spouse unless they have joint credit cards together. So when that happens, the filing spouse will have their debt discharged while the other spouse will still be liable for that debt. However, it won't have an impact on the other spouse's credit. So the bankruptcy won't affect the non-filing spouse, but they will still be liable for any debt that they co-own together.
Oh, wow. So that would make for interesting, spicy conversations around the dinner table, because
that might lead to a conversation to our offices.
Okay.
Yeah. So, I mean, a lot of times one spouse wants to keep their credit while they don't care if the other one does, so that at least one of the spouses has credit if they need something in the future or something like that. So that's sometimes the reasons that they do it. For those reasons.
But the other spouse is still going to be responsible for 100% of whatever that joint credit card is, correct?
Yeah. So they'll still be liable. If they were just an authorized user, then obviously that's different from being a co-owner. So if they opened up the card jointly, that's where they're going to be responsible. If they were just an authorized user on the card, then it's different. So they wouldn't be liable anymore.
So talk about the difference. I think some people get confused about what an authorized user is and what a co-owner of a card is. Steph, I don't know in your practice whether you've seen this too. I'm sure you have, where people say, oh yeah, it's his card, and next thing I know, it's really our card. So
right. So for bankruptcy purposes, opening up a joint card is where you guys put in the application together, the two couples put them in together, and both of their social security numbers are used. In the authorized user situation, it does get reported to the credit bureaus because a lot of people like to have that to raise their credit or whatever. If one spouse has good credit, they want to put an authorized user on. However, they're not responsible because they didn't open it up jointly. So the primary card holder would just add them on after. So the credit card companies wouldn't run their credit to open it up. their account up or anything like that. So they're just strictly allowed to use the card and charge on it, while the person who opened up the account is responsible for it.
You know, on the topic of credit cards and bankruptcy, I've seen a couple of times, and you probably have too a day, where we're going through the filing and I tell my client to get a copy of their credit report. And they find out that there's credit cards that were taken out by their spouse in their name that they were unaware of. How does the bankruptcy court handle that?
Yeah, so in that situation, that could be looked at as fraud if they did that without their knowledge. In that situation, the non-filing spouse, if they're going through a divorce and they're obviously, I'm sure, not on good terms, can bring an adversary proceeding. And that proceeding is basically a proceeding within the bankruptcy court that says that he should be responsible for these cards because he charged them on the credit card. So it could be looked at as fraud, which would be deemed non-dischargeable.
Oh, wow. And so out of those proceedings that you've handled, have any of them ever resulted in criminal proceedings as well?
Me?
Yeah.
No, not for me. I usually ask them this prior, but you never know if a trustee wants to bring an action for fraud or, you know. Have you guys ever had where a spouse filed and used cards?
I have had a situation where cards were opened by the other spouse without the other person's knowledge, and thankfully I've been able to not have to have the authorities get involved. But you know, like you said, you just never know, and you got to be so careful. People you know, do this sometimes as a matter of course in the way they live their lives, and you know, they come to folks like Steph and I, and also you, and say, oh, you got to get me out of this. And that's really, it's really important to know that in the event that somebody files for bankruptcy, you know, you could be brought into this thing. And the trustee, I guess, has the ultimate decision-making power on whether they're going to move it forward.
That's
to
true.
something that you don't want to be involved in.
Exactly. And, you know, when that happens, it's ultimately the trustee's decision whether they want to go after the other spouse to try to collect that money. And if he does, he can get that money and use it to pay the filing spouse's credit card debt if they wanted to.
Interesting. So, okay. So, if we can, I'm going to have a question about that with reference to petitions, Chapter 13 versus Chapter 7 petitions, and
Yes.
if that would make a difference. So if one spouse qualifies for a 13 but not a 7, and if they file separately, but if they file together, both spouses could only qualify for a 13. Can you just tell me the differences between the two types of petitions first?
For Chapter 7 bankruptcy, individuals have to qualify by passing a means test. And the means test takes into account an individual's last 6 months of income. In that situation, when two married couples are together and they are thinking about possibly filing before the divorce, if their incomes are too high over that median income, they won't be able to file a Chapter 7 and get their debts wiped out. So in situations like that, it may be best to file after the divorce, because then they don't take into account the spouse's income. So the income would be slashed in half.
Oh, okay.
So while if they file together, they would have to file a Chapter 13 bankruptcy if they're over that median income.
And what's the median income?
So the median income depends on the family household size in New York or in New Jersey. So there's different numbers, and the states basically have their own comparison of what they compare that to. So a household of 1 versus a household of 4, and what they need to be under to qualify for a Chapter 7. And the bankruptcy courts enacted that because they didn't want people with high income to be able to get rid of all of their debts and not pay them back. So it's essentially like a gatekeeping type of, you know, program where they keep people out from filing who they think should be able to pay back their creditors.
Okay. And then, so to clarify, the Chapter 13 is where you have to pay back some of your debt.
Right. So it depends on your income again and what assets you have. So if you have a lot of assets, they may make you pay the amount that you would in a Chapter 7 over the equity in your asset. Or in some cases where you have little assets, they may make you pay a certain percentage of your unsecured debt. So it just depends on what kind of assets you have and how much income you have to determine, you know, whether it's best income wise to file before the divorce or after the divorce.
Okay. And if you're filing in a Chapter 13 and you find that one of the debts that's in your Chapter 13 might have been fraudulent, like we were talking about, which is kind of rounding me back into the credit card issue, the bankruptcy trustee or the court can make the other spouse pay that credit card?
Yeah, I mean, they can bring it, like I said, an adversary proceeding against the spouse. It's a whole litigation process within the bankruptcy court. So it would go a different route if that's the case to see.
Interesting.
Mm-hmm.
So just as a reminder, if this is some really deep information, y'all, and y'all are getting it for free. I told y'all we're going to spill the tea today. So make sure that you share this video with your friends or family or whoever else you know who may be considering bankruptcy. Not that people tell you all their business, but in case they happen to slip, make sure you share this with your friends and subscribe to and like our page as well as Kara's page on Facebook. So so with respect to the level of cooperation that you need from a non-filing spouse, can you tell me what that looks like? So if the spouses are still married, but let's say that they're on the outs, what does the filing spouse need the non-filing spouse to do in order to move their bankruptcy process along?
So are you talking about if they are separated now or
they're still together? They're together.
Okay.
Right.
So the only thing that the court really needs from the non-filing spouse is their income, because like I said, the court looks at their household median income. So they're going to ask for pay stubs. Anything else, we don't really need the non-filing spouse's information. In some cases, if the one spouse owns property, this is the only thing, if the one spouse owns property and they both work and they're both paying the mortgage on that property, the trustee may have a claim that she is giving the money to a mortgage that he owns. So there may be something there. So that's the only thing that you have to be careful of, even though the non-filing spouse may not have property. If they are paying towards somebody else's mortgage, their husband's mortgage, who they may have an interest in, you just have to be careful, and you definitely want to speak with a bankruptcy attorney. So
right. And we'll preface all of this by saying that this is informational purposes only. Stephanie and I are not your attorneys, and neither is Kara, but if you want us to be, you can call us. So with respect to divorce and divorcing couples, one of the things that we as matrimonial lawyers are very sensitive to is the concept of equitable distribution and how that's impacted when people are filing for bankruptcy. So, you know, equitable distribution is defined the same way in New York and New Jersey. We are not community property states like California, I believe, is a community property state. We are an equitable distribution state, and so is New Jersey. And so, Stephanie, what does that mean? What is equitable distribution?
In the simplest terms, equitable distribution is just how the court is going to divide any marital asset. So from the date of your marriage to the date of your complaint, it's just how the court is going to divide that asset or those debts that you have accumulated during that time period. It's really simple. And it doesn't necessarily mean 50-50. It can, depending on the length of the marriage, depending on the type of asset, whole host of factors. It's very fact specific. Right. But I mean, that tends to be the starting point, even though it's really not. It's 50-50.
Right. Isn't that interesting? I always find that to be so bizarre, because it says equitable, not equal, people. It's not necessarily.
It's not.
And, yeah. And when we go into court, it's like, well, you know, I'm going to have 50% of that. Who told you that?
Who told you that?
I did not read that anywhere. Who told you that?
No.
But,
and, you know, overcoming that 50-50 is sometimes a really hard hurdle. Yes. And it shouldn't have to be that way, because there's really no presumption of 50-50.
There really isn't. And it's interesting because, you know, I like to tell my clients that the longer you're married, the more likely you are to have a 50-50 yes. Disposition. And, you know, there are certain cases where we're dealing with pensions and and annuities and things like that. And there's case law that really does stand on the side of that stuff being,
Yes.
you know, subject 50-50 during, you know, whatever was accrued during the time of the marriage. But, you know, you can really argue that. And if you have a good enough attorney who is able to make arguments based upon contributions and expectations and things like that, you know, it would probably behoove you to try, especially if you're talking about a significant amount of assets.
Yep.
But Kara, so how does bankruptcy impact us as matrimonial attorneys and our clients if we're in the midst or getting ready to file a divorce?
Right. So depending on when the individual should file their bankruptcy is really complicit on what assets are in this divorce case and what they will be getting after. So if there's no assets, it may not make a difference of when you file, right? However, if there are assets, you really want those assets in a divorce decree before you file bankruptcy, because you can't just say, okay, I'm going to give my spouse 15% of my house, or he can take the house and I'm just going to take something else. You can't do that. It has to be done fairly through the court, and it has to be pursuant to a divorce decree. If the spouse gives up property or interest in something that they could have had without that divorce decree, the trustee will look at that as a fraudulent transfer, a transfer to an insider, where they can go and sue the spouse to collect that money from that interest that they could have had. So it's really important that if you have assets, you know, and I don't want people to think that just because you have assets that you can't do a Chapter 7, or you may not be able to do it before the divorce. But you need to speak with somebody to determine when is the best time to file, either before or after. In addition to this, obviously, is the whole credit card issue of when a judge orders one spouse to pay another spouse's credit cards, which I guess you guys see a lot, I'm sure.
Yes.
In that situation, even if the filing spouse files bankruptcy and thinks that they won't be able to pay the non-filing spouse's debt, that is completely false. So that's something that everyone should understand, that if the judge has ordered you to pay your spouse's or ex-spouse's credit card debt, you will still be liable whether you file bankruptcy or not. The only person you won't be liable to anymore is the credit card companies. However, your ex-spouse can come to court, to bankruptcy court, and say, well, the judge ordered you to pay my debt, you owe me the money. So you're still on the hook for that. I mean,
right.
Is there any way, what if both spouses, let's say, each have $10,000, or let's say it's $100,000, because you're probably not running into bankruptcy court for $10,000 of credit card debt. So it's $100,000 of credit card debt, but each spouse has 50 on each of their sides, and they each agree in their judgment of divorce that they're each going to keep 50-50. But the divorce hasn't been finalized yet, or that's, you know, the term sheet, let's say. And what if one spouse files and discharges their 50? Is there anything that the other spouse can do?
I mean, they could, if it's their 50 and they discharge their 50, they can do that. However, the other spouse is still going to be liable for their 50, if that's what it says in the divorce decree. They can only discharge the debt that they're liable for, essentially.
Mm-hmm.
You know what? That is so interesting. It just made me think about a case that I had I don't have the case. Somebody had a strategy session with me about it. And this person had a divorce decree that made his spouse responsible for all of the debt, but made him responsible for paying her one half of the monthly payments. And then his spouse went ahead and discharged all of the debt. Meanwhile, the way that the filing spouse was collecting my prospective client's share of this money was as a credit against his interest in her annuities. And so I was like, oh my gosh. So basically she just had a whole windfall, right? and she's at a point where he's already waived his interest in her annuities. And so it was I consulted with this client on that, and I explained to him how dicey this whole thing was gonna get. And I was pretty clear that if he were to bring it to court, if he ever decides to bring it to court, that he'll probably be the victor and get back his interest in her annuities. But you have to be very careful. Your divorce lawyers will try to help you out of a situation as best we can, but you want to be mindful of the future impact of these types of agreements and how they could affect you in the end. Because in the situation I'm talking about, this person discharged 120 grand worth of debt. That's a lot of cheddar.
A lot. So definitely, I agree. It's all dependent on your divorce attorney, how they word things, and that's why you kind of want to work hand in hand with a divorce attorney, at least, or during the same time. You want to speak to somebody, a bankruptcy lawyer and divorce attorney at the same time, to see what's best for your financial situation. Everyone's different, so it's hard to give a blanket on everyone and when somebody should file. But
and I think it's important that if they're thinking about divorce and they're thinking about bankruptcy, definitely have the conversation before it happens.
Right.
And I think it's really important, I do it, is you have a conversation between the two attorneys as well.
Yes.
Because some things get lost in translation between the client and the attorney, and the client and the other attorney, and the client's reporting back. So you have to have, and I think it's important to have that conversation directly with the attorney and say, here's what is going to happen in the divorce process. Should he file, or should she or he file before the divorce or after the divorce? And what type are you considering? So
Absolutely. I think that's so true. And you know what? The thing about it is that people have to be candid with their lawyers. Look, Stephanie and I have definitely heard everything. We've been around. And so, I mean, there's almost nothing that you're going to tell us that's going to shock us. Although I was almost pushed to shock today when I was talking to a prospective client. I'm going to admit that. But I have another case where, the parties have already filed their divorce. They're not in court, but they've already filed. They haven't filed their RJI, and that's what we file in New York. We pay an extra $95 in order to get a judge assigned. It's so ridiculous. But anyway, I digress. But my client's spouse is filing for bankruptcy, and my client just told me this, and I'm like, but does the spouse's attorney know this? Does the spouse's MAT attorney know? And my client was like, yeah, I don't think so. I don't think that they told the MAT attorney. I'm like, what? Because my mind was blown, because we're dealing with assets, and there is a stay on the distribution of assets.
Stay.
Whether you file a 7 or a 13, right, Kara?
Correct. Yes, there is a stay. So
can you tell us what that means? Tell us what that means, so all the people know. So let the people know.
When everyone files bankruptcy, there's an automatic stay that goes into place, and that automatic stay basically prevents any court actions from proceeding, any creditors from garnishing, any divorce actions from continuing. So without the permission of the bankruptcy court, you can't proceed with your divorce case, with distributing assets and everything like that. So it's really important to let your divorce attorney know.
Absolutely.
You file bankruptcy, and make sure that they're on the same page, that it's okay if you're going to be going that route, because that could hold up your divorce case, obviously.
Yeah. And Stephanie, I mean, there's plenty of times where we have to access an asset during the divorce. We have to, sometimes we need to sell something. I mean, it could be a classic car. It could be a house. Sometimes we need to access funds in order to help the litigants fuel another part of their divorce. For instance, if you need to continue, you might be in a situation where the financial part of your divorce is stayed, which means it's halted. But if you have an issue with child custody or so on and so forth, and you need to hire a forensic evaluator or a custody neutral or somebody like that, and you're saying, oh, we don't have the money to do that. Okay, let's just pop over here and get this money from a HELOC, or let's just pop over here and sell this classic car. You're not going to be able to do that.
No, definitely not. During bankruptcy, you cannot be selling things. In Chapter 7, everyone's property becomes part of a bankruptcy estate. And what that means is that the trustee is in control of all of your financial property and assets. So you can't be selling stuff without the trustee knowing or their permission. It just doesn't happen.
Right. Also, isn't it true that aren't there also rules that prevent you from selling things like right before you file bankruptcy?
Yes.
So if you're like liquidating a bunch of stuff to fuel the divorce or any other purpose, the trustee could look back at that. Is that right?
Correct. So yes, there's a look back period before that can look like a fraudulent transfer. And in that case, the trustee will try to sue whoever you sold the asset to or whatever to try to get those funds back into the estate. So you don't want to be selling things right before filing bankruptcy. It's very, very, very important. So a lot of people don't know that there's a fraudulent transfer period. And it's really important. And especially, you know, sometimes it's not a big deal if you're selling the asset and you can show where the funds went and why it went to, but you know, it's case specific. However, you can't just sell a car that's worth $50,000 for $10,000 to your mom because you need to get $10,000. It's not going to work. Okay.
Right.
So the trustee will go back and say that this is a fraudulent transfer. You didn't sell it for a fair market value at the time and try to collect that money, that the difference in that money that should have been given to you at that time.
I could just see the sheriff now coming to get mom in the car. Lord, please don't have that happen. Please don't traumatize your mom like that. That's not right.
By the way, the fraudulent transfers happen with divorces all the time.
All the time, yes.
All of a sudden, a husband owes, you know, $500,000 to their spouse, and the next thing you know, they have nothing. Oh my gosh, this house! Nope, it went for nothing. It was under what? Oh gosh.
What if I take my name off the deed? I'm only on the deed. Can I just take my name off? I'm not on the mortgage.
Right? No, you cannot.
You own the mortgage is just a loan.
Right. You still own the property. Hello. And we're not helping you do any of that. We're not, because we need our licenses. We're not trying to be involved.
I am not.
But so how long is the look back period generally?
So usually it's 6 years, but in Jersey, we've had a trustee say that there is no look back period and they can keep looking back as long as they want. So I think it just depends on what trustee you get. The guy is a little crazy. There is case law that does coincide with what he's saying though, but most trustees usually look back 6-7 years, but
that's pretty long. 6-7 years.
Yeah, that's a long time.
It's a long time. But as long as you can say what you did with whatever the asset was, or you sold it for fair market value, or you know, not everything, not because you just sold something is technically a fraudulent transfer. It has to be something that you did. So if you took a name off your deed and gave it to your sister, that's where the trustee will want to get it. But if you sold it for fair market value, use those funds to live on or whatever you needed the funds for, your divorce case, that's okay, you know? So.
Wow.
Oh, so you can use them for your divorce case.
Going back, I mean, if you're going back farther, they're not going
okay.
If you liquidate them like a month before and say, I had 15,000 here, and that's a different story.
Darn it.
Yeah, I mean, that's a different story. So it has to be within reasonable time here.
On that, what about counsel fees for you? So if they have to liquidate something for a counsel fee to file for bankruptcy, is that going to be acceptable?
Again, if they're doing it just for, you know, if they're selling it because they're selling it for fair market value, but if they have 10, 15, well, over, so the exemption amount, the wild card exemption is 13,000. So they can have up to 13,000 of money sitting in their account if they're filing a Chapter 7. And these amounts double if there's multiple, you know, 2 spouses filing. But so technically, if they used it and it went to my fees, I guess they could, but our fees aren't $10,000. So, I mean, if it's 1,000, 1,500, I mean, I'm sure they're not going to say anything. They're not going to open up an estate and try to collect that amount of money, you know?
Right.
So different.
So what happens with respect to houses that are the subject of equitable distribution? If one of the spouses wants to stay in the house, what happens with that if the house has equity in it?
So as long as it's pursuant to a divorce decree and you gave up your interest in that property, that's okay as long as it says it in the divorce decree. The trustees won't go after it.
Okay.
If it's not in that divorce decree, and obviously it depends on the exemption and how much equity is in it, but that's not technically exempt unless it falls under the exemption. But if it's in that divorce decree and you give up your property, it's pursuant to the divorce decree. So
okay,
it's not a fraudulent transfer there.
And does it have to be a divorce decree? So I mean judgment of divorce. So it's a final agreement.
Final agreement, yes.
Okay. So if you have a property settlement agreement, that would not suffice.
Yeah, usually they like to, I mean, it might suffice. It may suffice actually, but usually they like to see that it was, signed by the judge, and just made sure. And it should be negotiated between two attorneys. So obviously there's these people. I had a client who went to, I don't know who they went to, but they didn't have a divorce attorney, and they were just negotiating on their own and decided to give up their property to the spouse because they just didn't want problems, and they're on good terms, and that's not okay. So that's not a real divorce decree. The trustees, if they wanted, I guess, could argue that, you gave up property. There was no negotiating here. It wasn't in your best interest when you negotiated this deal, and that you just gave up your property because you're on good terms now. So
right.
You do want to make sure it's pursuant to a divorce decree, a finalized divorce decree.
Do you think for that reason it's important to go through the final divorces before you file the bankruptcy versus filing it during or before?
So it depends. It depends on the situation. So if the filing spouse doesn't care about that property anymore, then they'll just file and give up their interest in it, right? I mean, what's it to be honest with you? If they want to keep the house, that's a different story. Then maybe, but it depends on how much equity is there. And sometimes, if there's enough equity to exempt, then it doesn't even matter. So the homestead exemption in New York is high. It's like 165 or something each for any person on the deed. So that's pretty high if they're living in the home.
What does that mean, just for our viewers, the homestead exemption?
Yeah, so that means that if you're living in that home, you can exempt and keep your property as long as the equity is under that 165,000, and that doubles for anyone else on the deed, or triples if there's 3 people on that deed and they're, you cut it down. New Jersey is different. New Jersey does not have a homestead exemption. They have a federal exemption, and that's only 25,000. So, yeah. So,
oh my gosh, you're about to lose your house. That's crazy.
So, unfortunately, for people,
nothing.
No, it's nothing. It's horrible, and I don't know, but with
depending on the day and the market, I mean, it's going to go up and down 25,000.
Right, exactly.
And the other thing to keep note of, especially now because of the virus, is foreclosure and whether your house is in foreclosure. And something like that, if your house is up for auction, you really have no choice. If you're trying to keep this house, you're going to have to file bankruptcy. If, whether you guys, if the main goal here is to keep this house. And I don't think there's a way in divorce court. I'm not sure. Is there anything that you guys do to stop anything, or no?
To stop a foreclosure?
Or do anything?
No. The only thing is just the bankruptcy. Right now, I know from another video I did with someone, they confirmed that the foreclosures are still stayed. Well, right, but it's only getting you out in the sheriff's sales.
Right.
So there's no longer the stay on the filing. So they can file for foreclosure and they can go through the process. But even if they get a judgment of foreclosure, you can't be out right now. So in a few months, a lot of people are going to be, once they lift that, a lot of sheriff sales are going to be coming through, and that's the problem. So if you want to keep that house and you're still thinking about divorcing, you're going to have to file bankruptcy sooner rather than later, because bankruptcy is really the only way to stop that foreclosure sale, whether it's a Chapter 7 or 13. A lot of people think that you can only keep a house as if you do a Chapter 13. In New York, they have a loan modification program, and which is really beneficial to people in both Chapter 7 and 13. And in New Jersey, they only have it in Chapter 13. So
you'd have to file 13 in Jersey. But that program really has helped a lot of debtors who otherwise fell behind on their mortgage and on their debts be able to get back up to date on their, mortgage arrears, which is nice. So
yeah, that's a good thing. Staten Island, I forgot about that. Staten Island does have the Volunteer Lawyers Project, and sometimes we refer people who come to us with arrears already, or they've already had a foreclosure file, but no judge has been assigned. We'll refer to the Richmond County Bar's Volunteer Lawyers Project to see whether they can help these people modify. But the other thing, and I did this recently as right before COVID, I remember actually being on vacation in Florida, driving to the bank to put money in to have my client have my client's mortgage paid with the money that I was holding in escrow. But we took that money out of a retirement asset, and so if there had been a bankruptcy or something like that, we would have been really precluded from doing stuff like that and moving money around like that. So all of these areas of the law are very well intersected. Listen, we were talking about fees. Stephanie asked you a question about fees. Let's just jump into it real quick. How much can somebody expect to pay for bankruptcies in terms of range? And I'm sure it depends upon what kind of bankruptcy they're filing.
Everything, and it depends what kind of filings that you're doing. So in New Jersey, for a Chapter 13, the no-look fee is $47.50. New York doesn't have a no-look fee for a Chapter 13, so most bankruptcy attorneys charge $5,000 and up, depending on how complicated, maybe $4,000. Some of them put it into the plan, so maybe you're not paying all of that up front, but you're paying it into the plan, and your plan payments are higher. In a Chapter 7, usually they range from $1,500 to $3,000. I guess $3,000 is very high. So, $2,500 mostly. And obviously it depends on whether you have a business, assets, and things like that. We
didn't talk about that at all.
Yeah. So businesses usually
do a part two.
Yeah.
That's what we need to do.
Just to do business. But businesses file Chapter 11. That's very different. I don't do that because that's a very specific area of law. It's corporations, and the bankruptcies range $20,000 and up to do something like that. Small businesses, however, will file Chapter 13, and there's a new subchapter 5 that they just started. So to help smaller businesses, it's very, very new. It just started this year. So
that might be important for a lot of businesses right now. I know there's a lot of these small businesses that can't open or doing some little online things, in a lot of restaurants, these small restaurants. I couldn't imagine if they had to come out of pocket and pay $10,000 to file bankruptcy. Yeah. I have one question. I know we're pretty much at our time limit, but there was a question I had from a client actually, and it was, if they file a Chapter 13, can their spouse be required to help them make any of those repayments?
So it really depends on the situation. So to help because it's their credit card debt as well. I don't think that they could be required to help them make those credit card payments. It's her filing the bankruptcy, and I mean, I guess you could try, but I don't.
Yeah, I mean, they would be individual.
Yeah, it would be cards. So but they're married, or they're divorced, or
married?
Married. Oh, they're married. They wouldn't know. So even he can help them, and she may need that to be able to fund a plan, but you can't require the non-filing spouse to be contributing to the filing spouse's plan. That's voluntary, whether they want to contribute to that plan or not.
Even if we crafted that into the equitable distribution.
Yeah, I mean, then again, they're supposed to be paying them back, so it gets into iffy terms here.
Okay.
You see, I would bet that if it was a part of the PSA, which is a property settlement agreement or a stipulation of settlement, that the bankruptcy court wouldn't have jurisdiction over that, but that the state court would be able to say, hey, listen, you're supposed to give Mary Jo 50% of this. And so where's her 50%, or where's Billy Bob's 50%?
Right, exactly. And that money could go to contributing to the plan. But when they're married, a non-filing spouse isn't required to pay for the filing spouse's debts. I mean, the one who files is the only one who's in bankruptcy. Whether they both want to do it, that's up to them. So but they have to be able to afford to fund the plan. So if she can't do it on her own, that's up to her. And if he wants to let the debt keep going and have the creditors go after him or her, that's up to the non-filing spouse, what they want to do.
This was really awesome. Kara, there needs to be like a part 2. We're going to figure it out, child.
There's a lot to talk about here.
There was a lot.
There was.
It was very informative, though.
Very informative. We really appreciated it. And we went a little bit over time, but I could probably go longer if we needed to.
There's a lot of good stuff. I think that our areas of law really, really do intersect, especially now, and the way people view, bankruptcy and divorce, and that it's like the end of their life. It's not. I mean, as you guys know,
get through it.
Get through it.
Get through it. That's right. You always, and that's the thing that's so important. You both know that my motto is turning fear into power when happily ever after fades away. When people come to us in these situations, they are so fearful, and that's normal. But hopefully they have really competent, give a damn lawyers like the three of us who can help them get out of it. And I will tell you that if anybody is, concerned about that type of thing, always make sure when you're in this type of situation, whether it's bankruptcy, whether it's divorce, don't forget to reach out to some of your resources who can help you navigate your way emotionally through these things. There is no shame in anybody's game with talking to a counselor, talking to your best friend, getting some kind of third party involved, because nobody's going to say that any of this is easy. And we recognize that while working with our clients, that none of this is easy. We just hope to make it a little bit more bright as we guide you through.
Yep, absolutely.
Definitely. And just one more thing, just so that everyone knows. Bankruptcy does not mean you won't get credit again. So everyone needs to know that, because I'm sick of credit repair telling them that. So I just have to put that PSA out there.
That is true. Bankruptcy might help you make sure you get credit again.
I'm not saying charge on those credit cards again.
I had a client a few years ago who their credit actually increased. Yes. Their credit score increased. I tell people this
all the time, that their credit scores may increase, and they don't believe me, but I swear I have nothing. I don't get anything from telling you this. But yes, in some cases where, how the credit bureaus calculate debt to income ratio, in some cases their credit goes up 100 points and they're shocked. So yeah, that happens.
Yeah, that's a great bonus. Okay, we can't promise that that's going to happen, people. Don't say that. Don't say that undoing I do told you that. Don't tell Kara that she promised you that your credit was going to go up 100 points. Don't do it now. Kara,
informational purposes only.
Informational purposes only, people. And share the link. Stephanie and I have started this as a labor of love, and we really do enjoy what we do. And we really value the ability to talk to so many more people than we would talk to in our ordinary practices. So make sure that you share. We will also Kara, make sure that you put your link to your Facebook page.
Yes, please.
I definitely will. And if you guys want to file bankruptcy or need to, I'm here. Thank you for having me.
Thanks, Kara.
For episode 2 of Undoing I Do, it's Stephanie in a Day.
All right. And so tune in next week. Same time, same place. Stephanie, what are we talking about next week? Lord. Okay, this is an unpaid co-host. Lord have mercy. COVID-19 and childcare. Okay, people.
I love it. Welcome. Thanks. Have a great day. Bye.